The moment those red and blue lights begin to flash in your rearview mirror, a sequence of events is set into motion that can fundamentally alter the course of your life. For most drivers, the immediate reaction is a surge of adrenaline, a dry mouth, and a desperate desire to be as cooperative as possible to make the situation go away. However, it is precisely this instinct to please that often leads to the most common pitfalls in a driving while intoxicated investigation. Understanding the mechanics of a traffic stop is not about learning how to beat the system through trickery. Rather, it is about understanding your constitutional protections and the specific tactics law enforcement officers are trained to use to build a case against you from the very first second of contact. One of the most subjective and frustrating reasons a person might find themselves in handcuffs is the vague categorization of acting weird. In the eyes of a patrol officer, any deviation from what they consider a standard social interaction can be documented as a sign of impairment. Consider a scenario in the quiet town of Silver Creek, where a driver named Julian is pulled over for a minor equipment violation, such as a flickering license plate light. Julian is naturally introverted and suffers from a mild social anxiety disorder. When the officer approaches the window, Julian's hands are shaking, he is stuttering slightly, and he avoids direct eye contact. To the officer, these are not signs of a nervous citizen, they are indicators of intoxication. Law enforcement training manuals often list fidgeting, inappropriate laughter, or excessive talkativeness as behavioral cues for drug or alcohol use. The problem is that these behaviors are also perfectly normal human reactions to the stress of being detained by an armed government official. When an officer decides you are acting weird, they are moving from the stage of a routine traffic stop into a criminal investigation. They are looking for reasonable suspicion to justify detaining you longer. If you are overly polite, they might call it overcompensation. If you are assertive about your rights, they might call it belligerence. This creates a no-win situation for the driver. The best legal protection in this instance is to maintain a professional, calm demeanor. You are not required to engage in small talk. When an officer asks, "Where are you coming from tonight?" or "Why are you so nervous?" they are not looking for a conversation. They are seeking admissions that can be used to justify a more intrusive search or a battery of tests. You can politely state that you do not wish to discuss your personal life or your day, and that you would like to know if you are free to go once the traffic citation is handled. The second tactic is perhaps the most deceptive, because it preys on the honesty of individuals who believe they are doing nothing wrong. This occurs when an officer shifts the conversation toward your health and medications. An officer might say, in a seemingly concerned tone, "You seem a little sluggish. Are you on any medications or under a doctor's care?" Many drivers, thinking they are clearing their name, will respond with something like, "Oh, I just took my blood pressure medication," or "I have a prescription for an anti-anxiety pill, but I took it hours ago." This is a catastrophic mistake. In the eyes of the law, DWI does not apply exclusively to alcohol or illegal narcotics. It applies to any substance, including those legally prescribed by a physician, that impairs your mental or physical faculties. By admitting you have a substance in your system, you have just handed the officer the missing link they need for a DWI drug arrest. Once you admit to taking a prescription, the officer will often call in a drug recognition expert, or DRE. These are officers with specialized training who use a 12-step evaluation process to categorize what kind of drug you might be on. However, the DRE process is widely criticized by scientific communities for its subjectivity. If you have admitted to taking a medication, the DRE's evaluation will almost certainly confirm that you are impaired by that exact category of medication, regardless of how you actually feel. Legal advice is clear here. Your medical history is private. You are under no obligation to disclose what medications you take to a police officer on the side of the road. A simple response of "I don't discuss my medical history without my attorney present" is a shield that prevents you from inadvertently admitting to the very element of the crime the officer is trying to prove. The third tactic involves the Standardized Field Sobriety Tests, or SFSTs, and it is a classic bait-and-switch maneuver. Before an officer begins these tests, they are trained to ask if you have any physical injuries or conditions that would prevent you from walking, standing on one leg, or following a light with your eyes. A driver with chronic back pain or a titanium rod in their leg might think, "If I tell him about my injury, he'll understand why I'm wobbly and he won't arrest me." This is a false hope. In reality, the officer is asking that question to lock you in to a narrative. If you mention an injury, they will document it, but then they will proceed with the tests anyway. When you inevitably struggle with the one-leg stand because of your bad back, the officer will write in their report that you failed to perform the test as instructed. Later, in court, the prosecution will argue that the officer took your injury into account, but that your performance was still poor enough to indicate intoxication. The SFSTs are not tests in the traditional sense where you can pass or fail based on effort. They are divided attention tasks designed to look for specific clues of impairment. For example, in the walk and turn test, there are 8 specific clues, such as starting too soon, losing balance during instructions, or taking the wrong number of steps. If you exhibit just 2 clues, the officer is trained to believe there is a high statistical probability that your blood alcohol content is above the legal limit. These tests are voluntary in many jurisdictions, although the officer will rarely inform you of that. They are performed in the worst possible conditions, on the side of a busy highway, at night, with gravel underfoot, and strobe lights flashing in your eyes. Refusing these tests is often the smartest legal move, as they are specifically designed to provide the officer with the probable cause necessary to arrest you and force a chemical test. Moving to the 4th tactic, we encounter a scenario that feels like a gross miscarriage of justice: the arrest of a passenger. Imagine a scenario in the city of New Carthage, where a driver is pulled over for a DWI investigation. The passenger, a friend named Marcus, is completely sober and is sitting quietly in the passenger seat. Marcus knows his rights. He keeps his hands visible and remains silent, exactly as legal experts recommend. However, the officer may find Marcus's presence or his silence to be an obstacle. If Marcus tries to record the interaction with his phone, which is a constitutionally protected right, the officer might claim Marcus is interfering with an investigation or obstructing a peace officer. In some cases, if the driver is arrested and the car is to be impounded, the officer might order the passenger out and then arrest them for public intoxication, even if the passenger was merely trying to get a safe ride home. This tactic is often used as a tool of intimidation. By putting pressure on the passenger, the officer hopes the driver will become more compliant or offer up more information to save their friend. The passenger is in a precarious legal position. While they have the right to remain silent, they must also be careful not to physically interfere or reach into areas of the car that could be construed as reaching for a weapon. For a passenger, the best advice is to remain as still as possible, record the interaction if it can be done without reaching toward the officer, and avoid any verbal confrontation. The goal is to remain a witness, not a co-defendant. The 5th and final tactic involves the sleeping it off arrest, which catches many responsible people off guard. There is a pervasive myth that if you feel you have had too much to drink, the safest and most legal thing to do is to pull over and sleep in your car until you are sober. Unfortunately, in many states, this can lead to a DWI charge under the doctrine of actual physical control. In a town like Oak Ridge, a person named Sarah might realize she shouldn't be driving, so she pulls into a well-lit parking lot, reclines her seat, and falls asleep. An officer patrols the lot, sees her, and knocks on the window. Even though the engine might be off, if the keys are in the ignition, or even just within reach in the cabin, the law may consider Sarah to be operating the vehicle. The prosecution's argument is that Sarah could have woken up at any moment, turned the key, and driven into traffic while still impaired. This intent, or capability to drive, is enough to secure a conviction in many jurisdictions. To avoid this trap, the legal advice is incredibly specific. If you must sleep in your car, do not sit in the driver's seat. Put the keys in the trunk or even outside the vehicle on a tire and sleep in the back seat. This makes it much harder for the prosecution to prove you had actual physical control of the vehicle. However, the safest option is always to leave the vehicle behind entirely and call a ride-sharing service. Throughout all these scenarios, a common thread emerges. The power dynamic between the officer and the citizen is heavily weighted toward the officer. The officer has the training, the badge, and the ability to control the narrative in their written report. This report is often the only version of events a prosecutor or a judge will see for months. This is why it is vital to understand that your words are your greatest liability during a stop. Every yes sir or no officer that includes an admission of where you were, what you ate, or what medications you took is a brick in the wall the state is building against you. People often feel that if they are cool with the officer will give them a break. While officers are human and can be empathetic, their primary job during a DWI stop is evidence collection. They are looking for reasons to justify the arrest they have already mentally decided to make. The mixed paragraph style of these interactions, alternating between the high-pressure environment of the roadside and the cold, calculated reality of the courtroom, highlights the disconnect between a citizen's intent and a legal outcome. You might intend to be helpful by explaining your knee surgery, but the legal outcome is a documented failed physical test. You might intend to be a responsible citizen by sleeping in your car, but the legal outcome is a physical control DWI charge. The law does not always care about your intentions. It cares about the elements of the offense as defined by statute. To protect yourself, you must be your own best advocate from the moment the interaction begins. This starts with your driving behavior, ensuring your vehicle is in good working order and you are following all traffic laws to avoid the initial stop. If you are stopped, pull over in a safe, well-lit area. Turn on your interior light so the officer can see inside, which can de-escalate tension. Keep your hands on the steering wheel. When asked for your license and registration, inform the officer where they are before reaching for them. Once the paperwork is handed over, the educational portion of the stop ends and the legal advice portion begins. You do not have to answer questions about your destination or your consumption. You can say, "Officer, I am not going to answer any questions without my lawyer present." This may frustrate the officer, and they may even tell you that only guilty people need lawyers, or "You're making this harder than it needs to be." These are psychological tactics designed to make you waive your Fifth Amendment rights. Stay firm. Furthermore, it is important to understand the difference between the breathalyzer at the station and the portable breath test, PBT, at the scene. In many states, the PBT you are asked to blow into on the side of the road is not admissible as evidence of your actual BAC level in court. It is only used to establish probable cause for the arrest. You often have the right to refuse the PBT without the same harsh license suspension penalties associated with refusing the official evidentiary test at the station or hospital. However, implied consent laws mean that if you refuse the official test after being arrested, you will likely face an automatic suspension of your driver's license. This is a complex legal crossroads that varies by state, and having a plan before you find yourself in that situation is essential. The goal of this guidance is to empower you with the knowledge that law enforcement tactics are standardized and predictable. By recognizing when an officer is trying to get you to admit to medication use, or when they are using your passenger to rattle you, you can remain composed. A DWI arrest is a traumatic experience, but it is not a conviction. Many cases are won or lost based on what happened or didn't happen during those first 20 minutes on the shoulder of the road. By refusing to give the officer the weird behavior they are looking for, by keeping your medical history private, and by understanding the inherent bias in field sobriety tests, you provide your defense attorney with the tools they need to fight for your rights. The legal system is built on procedures, and when officers take shortcuts or use subjective observations to replace objective evidence, the system can be held accountable. Your job during a stop is not to win the argument with the officer. Your job is to remain silent, remain safe, and preserve your ability to fight the case in a court of law where the rules of evidence and the presumption of innocence still apply. In the end, the most practical legal advice is to treat every interaction with law enforcement during a traffic stop as a formal legal proceeding. The side of the road is the courtroom, where the officer is gathering the evidence that will be used to prosecute you. Do not give them a confession disguised as a casual conversation. Do not give them a fail on a physical test that you were never designed to pass. And most importantly, do not let the fear of acting weird or the desire to be the nice guy lead you into a situation where you are signing away your freedom. Protecting yourself from a wrongful DWI arrest requires a combination of silence, awareness, and a steadfast commitment to your constitutional rights, even when the pressure to fold is at its highest. Knowledge is your best defense against the tactics used to turn a simple drive home into a legal nightmare.